Expectations are high as Justice Kudirat Kekere-Ekun takes over as the #1 law officer of the country. The appointment of Justice Kekere-Ekun was announced on Thursday after the National Judicial Council's 106th meeting, which was held on August the 14th and 15th. President Bola Tinubu swore in Justice Kekere-Ekun as the CJN in acting capacity on Friday. Meanwhile, following the recent floods and droughts that have ravaged farmlands in different states in the northern part of the country, agricultural experts and big-time players in the agro-allied industry have sounded the alarm over an impending food crisis across the country as agricultural fortunes dip in the north. This is Standpoint. I am Precious Amayo. Justice Kekere-Ekun, who is assuming office as the Chief Justice of Nigeria, at a time major observers rate the judicial institution low, is the country's second female CJN after Justice Mariam Aloma Mokhtar. Justice Kekere-Ekun, who has delivered numerous lead judgments, is not new to major decisions that have created mixed reactions. Delivering the lead judgment in the case of Uzodinma versus Ihedioha over the Imo State governorship dispute in January 2020, Justice Kudirat Kekere-Ekun stated that the matter seeking to disqualify Uzodinma raised fresh issues that could only be brought through leave of the Apex Court, adding that being a pre-election matter, it could only be commenced at the High Court as provided by Section 87, subsection 9 of the Electoral Act. In January 2024, Justice Kekere-Ekun also presided in the case of Governor Muhammad Nuwa Yahaya of Gombe State, where her lead judgment dismissed the appeal of the People's Democratic Party's Mohammed Badi challenging the March 18, 2023 elections. Justice Kekere-Ekun also presided over the case between the PDP and another versus barrister Sopoluchukwu E. Eziomuka and another to 2017, when she held that the court must use its records and file to arrive at substantial justice in any jurisdiction. By this, she established the importance of recording and in determining matters before the court as the primary source of exhibits and evidence involved in the case. Now, as Justice Kekere-Ekun assumed office, we're going to look at what all of this means. They will also profile, just look back at the tenure of the CJN, that's the former CJN, also in this matter as well. But let's just take a look at some of the conversations, sound bites that we've been hearing from people during her swearing in and then just concerning what they expect from her tenure.
At this point, for distinguished lordships and his excellencies that are here, the president also has for the judiciary the acting Chief Justice of Nigeria just took her oath. Before she will take the full designation as the Chief Justice of Nigeria. Of the Federal High Court. At this point,
well, let's now have this conversation about, the tenure of the former CJN and then the new CJN, acting CJN rather, before she is confirmed by the Senate. Let's bring in lawyer Bolale Olugbani. He joins me in the studio to speak more on this. Good to have you join us.
Thank you. Thank you for having me.
So one CJN out, another in. This is not the first time we're experiencing this in the country. We've seen different CJNs come in and go. The thing with the work of the CJN is that there is no tenure to it. Once you're 70, you're out. But let's talk about the former CJN, Ariwoola, who has now bowed out. What would you say, are the highlights of his tenure?
Well, the tenure of the former CJN, Justice Ariwoola, was characterized by controversy, perhaps needless controversy, in the appointment of people who had filial relations with him, his son, his daughter-in-law, and certain appointments. That's the most that was carried by the press generally about his tenure. But I think that he tried to impact on the justice delivery system by enforcing discipline through the National Judicial Council in respect of erring judges, and generally trying to ensure that the judiciary delivered more in terms of performance. And those who did not meet their performance quotas with regards to judgments were issued a lot of queries. Judges who petitions were written against, those petitions were tried, and sanctions were imposed. So generally, it may not have been characterized by a lot of known achievements, but I think that it was okay.
When you say not known achievements, some will say, look, when you look at the proceedings around the presidential election and that judgment that was delivered, yes, at the Supreme Court, and that is unprecedented. Yes. And then, because some have said, lawyers like you have said, it was very thorough. Yes. Some have also talked about the Local Government Autonomy Bill Act that we now have. Others have mentioned issues around the cash scarcity we had at some point, and the role that the Supreme Court played in ensuring that the CBN wasn't acting out of law. And so, would you not look at that and say, oh, well, that's a great legacy?
Well, those are the quote and unquote unknown achievements. They are known, they are actually in our faces, but it took some kind of proactiveness from the Supreme Court to have those things, decided, definitively and, within a speedy period of time. So those are achievements that you just mentioned. But because the Supreme Court of Nigeria does not, blow its own trumpet, and more or less litigants have to bring matters before it as a court of final arbiter in the judicial system, many would not really look at the benefits of those decisions, as it affects the nation. So those decisions were saving decisions that were life-saving. Some, established the superiority of the Constitution, that is the local government autonomy, which guaranteed the system of local government, but which system was being manipulated by the state governors. And, the financial autonomy too, was a good, pronouncement from the Supreme Court. Well, of course, there's a ministerial committee now doing the implementation and all that. So those are actually the achievements which, by nature of the judiciary, those decisions cannot be ascribed to a particular CJN but these were groundbreaking decisions of the Supreme Court under his tenure.
As he bows out of office, I mean, we've seen that with, again, every CJN, when they leave in office, they call for reforms. And people wonder, why didn't that happen during your own tenure? But he has talked about the fact that the Supreme Court is overburdened, and perhaps that should be reduced. People, of course, that would take, it's a matter of the constitutional review, because some of these things have been stated in the Constitution of what the Supreme Court should do or cannot do. And so I wanted to ask you, is the Supreme Court really overburdened, and how should that be addressed?
Frankly speaking, as a practitioner, I think the Supreme Court is overburdened. I think that the inheritance of a constitution which was midwifed by the military, you know, laid the foundation for the overburdening of the Supreme Court. The Supreme Court, with only 21 justices, you know, by virtue of Section 230 of the Constitution, has a maximum number of justices that you know that are in the Supreme Court. You know, 5 justices sitting, except when there's a constitutional issue, 7 justices will sit. There are not enough panels, not enough Supreme Court justices to take the volume of the appeals emanating from the Court of Appeal. The Court of Appeal itself has so many divisions, you know, all over Nigeria, and appeals from those divisions eventually land at the Supreme Court, which is undermanned. So it will require a constitutional amendment to have more Supreme Court justices, more Supreme Court panels to hear the volume of cases. Of course, there's a suggestion that certain cases should end at the Court of Appeal. But of course, those type of cases should not be matters that have to do with life, criminal appeals, where there's a death sentence. It should not have to do with land matters that the entire gamut of the judiciary should be exhausted before, you know, the litigants accept. It should not involve chieftaincy and obership, emirship, you know, tussles that the Supreme Court needs to make a clear pronouncement and allow the litigants to totally explore all opportunities before they accept a final decision. But I think that the new acting Chief Justice of Nigeria, who has a very remarkable career, started as a magistrate, chief magistrate, got appointed.
So have been in every court.
Every court.
And I will touch on
experience.
I'll touch on her, you know, soon. But I wanted to get back to the fact that even because you have mentioned the fact that there are 21 justices of the Supreme Court, yes. I think this is the first time in a long time where we're even having them.
Yes, a full
you know, complement
yes.
of the justices, and this administration did that. So, yes. But I also wanted to talk about the idea of stopping at the appeal court.
Yes.
We see that during elections where cases of the National Assembly,
yes.
You know, revolves around elections of National Assembly, yes. stop at the appeal court.
Appeal court, yes.
But we saw what happened in Plateau State.
Yes.
The cases at the appeal court went against the lawmakers in Plateau State.
Yes.
But when it got to the Supreme Court for the gubernatorial election, it yes. went in favor of the governor. And people said perhaps if it had gone to the Supreme cases had gone to the Supreme Court, yes. they would have also gotten favorable judgment. Yes. And so when you look at those kind of situations, yes. perhaps that's why people want to get to the Supreme Court. So isn't then a question of strengthening the lower courts?
Well, that may be, you know, a solution, but I think that the better solution is to increase the number of Supreme Court justices and perhaps decentralize the Supreme Court. There should be a Supreme Court for, I think, every geopolitical zone of this country. With a greater number of justices at the Supreme Court should not only sit in Abuja for each geopolitical zone, making up the number of states in every geopolitical zone. Appeals from the Court of Appeal in that division should go to like a regional Supreme Court, which is, of course, an extension of the Federal Supreme Court. Or in the alternative, a constitutional amendment should be made to actually have state Supreme Courts, which have equal power.
Mr. Olubani, you
yes.
want to put us in a situation where we are getting conflicting orders. I mean, look at what we're going through at the moment at the lower court,
yes.
where we are getting conflicting, you know, judgments from you know, courts of coordinate jurisdiction. And yes. people are saying, right now, that has to be dealt with. If you have Supreme Court, we know that the issue of the Supreme Court is final, but if somebody decides to take one case to the Supreme Court, yes. and that person goes to the Supreme Court in Abuja, and that goes to the one in Lagos, are we not now going to have finality of decisions, you know, all around the country?
No, we will not be having Supreme Courts of coordinate jurisdiction. It will still be one Supreme Court, but in a decentralized form. All of these justices, whether it's a geopolitical Supreme Court or a state Supreme Court, will still be justices of the Federal Supreme Court, but will be sitting with jurisdiction to hear final appeals coming from, you know, certain geopolitical zones or certain number of states as a division of the Supreme Court. I'm saying that the Supreme Court should actually have divisions, like the way the Court of Appeal is, as a final determiner of issues from, say, the geopolitical southeast, the geopolitical southwest, the north central, the southeast, south, so that justice is made accessible to the ordinary man on the street without a huge cost you know, in attaining justice. They are all going to still be...
And then you also look at the length of time
yes,
it takes sometimes, you know, to get justice.
Yes.
But let's talk about the new acting CJN,
yes,
who the president, you know, while swearing her in yesterday as the acting CJN, had very glowing words about her career. But he also said something which was very, I thought was very profound, is the fact that he said the position of the CJN is one that comes with enormous responsibility and influence. And so I want us to start from there. You know, now when you look at the judiciary, the trust deficit is at its precipice. People feel like they are not getting justice, especially because of the some of the cases around, you know, election litigation, cases around people who have not been enforcement, or sometimes even just the enforcement of court orders. And what task lies ahead of her as the new CJN in terms of restoring the integrity of the judiciary?
Well, Mr. President also gave an additional, you know, suggestion that the new CJN should ensure the independence of the judiciary. The independence of the judiciary, quote and unquote, is a very big topic. But I'm just going to take your question and, you know, so this CJN started her career, judicial career, as a chief magistrate, was a high court judge, was a court of appeal justice, eventually got appointed to the Supreme Court, and is now the acting CJN. Now, there's a lot of experience. A lot of experience with the role the judiciary plays in bail that affects awaiting trial inmates, bail that affects the possibility that people, you know, have, you know, their freedom whilst attending court. This awaiting trial syndrome or problem that we have with our judicial system and the prisons, you know, makes it that about 3/4 of those in our prisons are not people who are actually convicted or, you know, sentenced for criminal offenses. These are people who are still undergoing trial. Those trials are either being, you know, delayed, or the prosecution is not doing its work diligently. The CJN, you know, is the head of the judiciary. There are three arms of government: the executive, the legislature, and the judiciary. And by our constitution, they are co-equal branches. So as head of the judiciary, I believe that there's a need to have a synergy between the Nigerian bar, the prison system, the police, and all those prosecuting agencies like the NDLEA, EFCC, to put in place rules, regulations, and even laws that shorten the time which a diligent prosecution must be, you know, conducted. Once it's out of that window, magistrates, judges should take the bold step, the initiative to strike out those matters. So unwarranted delay in the judicial process should be one of the priorities of the new CJN, by involving the state chief judges to ensure that rules of court are extended to affect criminal prosecution, thereby ensuring that justice delayed is not justice denied, and that the overcrowding of the prison system, you know, is minimized. Then, of course, litigation takes a long time. The rules must be put in place through the synergy of the bar, synergy of the judiciary, the chief judges, the attorneys general, and all those who are stakeholders in the judicial system, to find a way to ensure that all of what is required to make a trial, where a matter must go to trial, to make a trial speedy, we must continue to work on it, to fine-tune it, to ensure that trials are not only held within the shortest possible time, a time frame must be created, and sanctions must be imposed. Even greater sanctions must be imposed for those who seek to delay. Any litigant who is delaying must, you know, get those sanctions so that they do not waste time with cases in court. You know, matters, you know, taking 14 years, 12 years, 18 years shouldn't be heard of in this our time. Then finally, I think that you know, there's a need for an increase in the number of judicial officers. 3 judges of the High Court of Lagos State alone, their dockets, 800 matters, 1,000 matters, 1,200 matters. 3 judges of the High Court of Lagos State, the cases they have in front of them is even greater in number than the cases in the entire judiciary of some of the 36 states of Nigeria. Lagos in particular, a highly commercial, highly developed, a very sophisticated state in terms of everything, deserves more judges. Even if they have 150 judges, it's not going to be enough. to reduce the workload.
If I may quickly come here, because for Nigerians, the issue is not even more of delayed justice.
Yes.
It is more of denied justice.
Yes.
The Nigerians who feel like some people are above the law, there's a perception of that influence over the judiciary, over the bench especially, where people feel like, oh, if it's this person, well, this person is likely going to have influence because, you know, there is money, there is power over the common man who they feel, well, you're never going to get, you know, justice. And so, again, that's the biggest issue for Nigerians, where they feel like some people have more power, some people are above the law and have influence over the bench. Yes. That's a lot of work for her, I can imagine. But yes, where should she start from in you know, demystifying that kind of perception and ensuring that, you know, there's transparency in the judicial system?
Well, I think that, first of all, we members of the justice sector, and in fact the judges who are appointed, must stop giving the impression that there's a way around the rule of law, evidence, and how cases are done and won. A lot of this misconception or the bad image of the judiciary comes from us, the lawyers, who tend to give clients the impression that there's a way or access to a particular judge or a judicial panel or a way and manner something must be done before you achieve certain results. All of this must stop. We must be above board. We must first check ourselves. The body of benchers, the body of senior advocates of Nigeria, the Nigerian Bar Association must take a proactive step in reorientating lawyers themselves. And lawyers who do anything that is extra-legal or illegal in regards to influencing the judiciary must be sanctioned. We must out those of us within the profession who are doing things that are less than scrupulous. That's one thing. Then the second thing, the judiciary must not engage in any form of judicial self-censorship. The idea that an application is brought and it's an ex parte application which does not necessarily give the other side, you know, the room to, you know, respond before an injunction is granted, you know, we must look at that. The fact that we're in a situation where judges, you know, are giving the impression that they must not or cannot or should not, you know, take decisions against their state governments, their state governors, or certain vested political. There must be an orientation amongst judicial officers that they have an independence, a judicial immunity to take decisions based on the law and based on the facts of the case, without any encumbrance, direct, indirect, legal, extra-legal, or any form of influence that tends to make them do or not do what they are supposed to do. So orientation through workshops, seminar, and all other forms of things must give the judicial officer the mindset that he is the lord of his court, and based on the evidence and the law before him, he is free to take decisions that he needs to take to ensure justice for not only the rich but for the poor.
Well, what about the issue now in Rivers State? I mean, that's one that is very shocking for a lot of people. It's making everyone wonder, what is the judiciary doing and what are lawyers doing, where you have several court judgments, and then you have politicians now cherry picking on which one, you know, to follow, the one that suits them. And so we have a situation where politics in that state is at limbo, where the governor says, look, this is the judgment from this particular court. The other side says, this is the judgment from this court. And so a lot of court judgments. In those kind of cases, you know, where they are sometimes coordinate jurisdiction, sometimes not coordinate jurisdiction, who should be sanctioned? Is it the lawyers or the judges themselves?
Lawyers have a big role to play in this confusion. Lawyers know the courts and they know the jurisdiction of the different courts. Section 250 of the Constitution tells you about the headings or the jurisdiction of the Federal High Court. It's clear. The state high courts have virtually unlimited jurisdiction except for matters listed in Section 250 of the Constitution, which is the exclusive preserve of the Federal High Court. So every lawyer is trained to know what court he ought to approach to seek remedy or justice for his client. But the idea is that depending on the way certain causes of action, you know, arise, or in the way and manner litigation is couched or framed before it is filed in court, it may give a conflicting impression as to whether the court which it is going before has jurisdiction over the matter. But I think the solution is very simple. The new Chief Justice of Nigeria should make all possible efforts to have a situation where nationally, statewide, at the Court of Appeal, anywhere, there is an online registration of court rulings and court judgments. What I mean is that in real time, once a judge of the High Court of Lagos State, a judge of the High Court of the Federal High Court, for instance, these are courts of coordinate jurisdiction, but with different headings, and there are some similar, like banker, customer, they have equal jurisdiction. And so when you make a judgment, when you give a ruling, it ought to be registered online for a matter of similar flavor with maybe equal or the same types of litigants, plaintiff, defendant, coming before you, whether it's chieftaincy, whether it is couched as fundamental human rights, where an online search can be done by the judge or his support staff immediately to see whether any other court, whether higher court, superior court, or court of coordinate jurisdiction has made a pronouncement on the matter. That way, we can avoid conflicting decisions of the high courts or courts of coordinate jurisdiction and infra-dig decisions of a lower court seeking to make a pronouncement on a matter that a higher court has assumed jurisdiction over. So real-time online registration of judgments and rulings for all courts in Nigeria.
Correctly,
yes.
It's one of the things you think that she should embark on.
Yes, it's
digitalizing
yes,
court processes.
Yes, please. I think it's very important for the safety and the credibility and the integrity of the judiciary during her tenure.
So let's also talk about, I know that the judiciary doesn't have its own security agencies,
yes, and
means of enforcing court judgments.
Yes.
Because she now is being the Chief Justice of Nigeria. What it means to a lot of people would be being a custodian of justice. Yes. But we have situations where judgment debtors do not want to adhere, to the judgments in courts and then settle with their, judgment creditors, especially in the executionary judgments. And so what can she do in teaming up with security agencies to ensure that if there is a judgment, that judgment is enforced?
Well, if there was any other title I could have given you right now, I would have said you were a mind reader. Because what you have just asked is one of the most important questions with regard to justice administration in Nigeria. I don't think that the Chief Justice of Nigeria should be taking steps to have any form of relationship with the appropriate law enforcement agencies for the enforcement of court judgments, rulings, and whatever it is required that the judiciary relies on law enforcement to do to make what it does effective. I think that the Chief Justice of Nigeria should push for a unit or a section within the Nigeria Police Force and other relevant agencies which will be separate, created separate and distinct, and it should be a judiciary police. The judiciary needs to take charge of its own enforcement and not rely on the executive arm or indeed the Nigeria Police Force or any other law enforcement agency to give effect to its judgments and rulings. What I mean by that is this. You can decide that a DIG is the head in the present structure of the Nigerian police, should be the head of the judiciary police. He's next only in line to the IG. But from the minute he's appointed as the head of the judiciary police, he ceases to take instructions from, as the ultimate authority, from the Inspector General of Police. He will then take instructions ultimately from the Chief Justice of Nigeria as per enforcement and maintenance of and enforcement of court judgments and court rulings. So that in every state, attached to every court, the judiciary police is responsible for the enforcement of court judgments that removes the discretion of the Inspector General of Police, the executive arm, and makes the co-equal branch as established by the Constitution, that is the judiciary, actually co-equal in word and in deed with the other two arms, which is the legislature and the executive arm. So I think that in this tenure of the current acting Chief Justice, who will be confirmed sooner than later by the Senate, I think that there should be a push for a constitutional amendment to create, whether administratively or by constitutional amendment, a judiciary police that answers only to the various chief judges of the state and indeed the Chief Justice of Nigeria. That way, justice delivery, the influencing of this and that, the use of the illegal use of law enforcement to prevent the execution of court judgments, the cherry picking in obeying court judgments, all of that, a stop will be put to it.
What are your expectations from her, and what do you think that, look, if she can do this one thing, she would have at least raised the standard and then cement the independence of the judiciary?
Well, one of the things that is very important to the stability and the performance of the judiciary is the welfare of judicial officers. You know, there's just been a 300% increase, you know, for the salaries of judicial officers, the first in 19 years. So inflation has caught up and overtaken all of their legitimate income a long time ago. So it's the right step by the president and indeed the Federal Attorney General, but we need to go further. We need to go further in ensuring that this increase in welfare and salaries is tied to a law, a percentage increase every year or every 2 years by operation of law. Secondly, courtrooms in most states, you know, the judiciary, at the head of the judiciary, that is Chief Justice of Nigeria, must step in directly. What you consider to be magistrate courts in many states, customary courts in many states, because of lack of funding, lack of provision of adequate facilities, is an eyesore. It's an eyesore. And then we must also ensure that the judiciary staff who are wont to go on different strikes, thereby crippling the activities of judiciary, you know, when it comes to their own welfare, when it comes to the things that they believe are their rights, you know, the Chief Justice of Nigeria should take a critical look at it and ensure that those who are the support staff, the people who are members of JUSUN, Judiciary Staff Union of Nigeria, you know, all their issues or most of their issues during her tenure, I don't know how long her tenure will be, you know, should be adequately addressed holistically, you know, to put a stop, a stop to the embarrassing, you know, downing of tools, you know, and which stops the speedy dispensation of justice, and, you know, which creates the impression that justice delayed and is justice denied for the poor and for the rich, you know, during those strikes.
Interesting conversation with you. We're looking forward to the tenure of the new acting CJN and a confirmation as well, and see what she's able to bring to the table in terms of justice delivery. You're spoken like someone who aspires to the bench yourself, so we will see how, you know, things play. Thank you so much, Mr. Bolanle Olubani, a lawyer, for helping us break this down.
Thank you very much.
All right, so let's take a break now. There is another very profound issues that matters to Nigerians, which is food on the table, the cost of living. But as we speak, there are a lot of issues affecting farmers in the country, whether it's insecurity or climate change, and flooding as well, which is part of the climate change issues. We're going to look at all of that with an agribusiness analyst, Dr. Olukayode. He's standing by for us, but that conversation would be after the break. Stay with us.